Senator Leahy assured me that the only way he could make it this morning was to sleep in his car in the garage last night. So we want to thank him for being here at the start of the meeting. Today we're going to consider one U.S. attorney and one bipartisan bill. First, one bill has been listed for the first time on this week's agenda and will be held over. S. 3846, Justice and Mental Health Collaboration Reauthorization Act, introduced by Senators Cornyn, Klobuchar, myself, Whitehouse, Tillis, and Grassley. Before I turn to today's agenda, I'd just like to make a couple observations about the news of the moment. Tuesday night, Justice Alito's draft majority opinion in Dobbs versus Jackson Women's Health Organization was published by Politico. Millions of Americans were shocked to learn that this draft opinion would actually overturn Roe versus Wade. Why were they shocked? It may be because this committee's recent Supreme Court hearings it took the nominees at their word. At least 4 Republican appointees who currently sit on the Supreme Court appeared as nominees before this committee and claimed they would respect the court's nearly 50-year precedent on a woman's right to choose and treat it as settled law. They assured us they would not be activist judges. They portrayed themselves as neutral umpires, driven not by policy objective, but by a desire to call balls and strikes, to adhere to precedent, to simply apply the law to the facts. This draft opinion tells a much different story. Consider what then Judge Alito, the draft's opinion author, told me when he appeared before the 2006 confirmation hearing under oath. I asked then Judge Alito if he viewed Roe as settled law. He responded, and I quote, "If settled means that it's a precedent that is entitled to respect as stare decisis, and all of the factors that I've mentioned come into play, including the reaffirmation and all of that, then it is a precedent that is protected, entitled to respect under the doctrine of stare decisis," end of quote. President Trump's 3 Supreme Court nominees paid the same lip service to Roe and Casey. Then Judge Gorsuch testified that both Roe and Casey, and I quote from his sworn testimony, "precedent of the U.S. Supreme Court worthy as treatment of precedent like any others," close quote. Then Judge Kavanaugh said that Roe was, and I quote him again, his statement under oath, "important precedent of the Supreme Court that had been reaffirmed many times," end of quote. Then Judge Barrett committed that when it came to cases like Roe, she would, quote, "obey all rules of stare decisis and apply its relevant factors," close quote, including reliance and workability. If this draft opinion becomes the court's majority opinion, these nominees will have shown again what we've said for years about certain appointees to the bench. They are, in fact, judicial activists. They are driven by desired policy outcomes and beholden to an ideological agenda. And make no mistake, this would be judicial activism. These justices were put on the bench by President Trump and Senator McConnell to deliver this outcome. President Trump said as much when he promised he would appoint justices who would, quote, automatically, in his words, automatically overturn Roe. And Senator McConnell proudly held open a vacant seat on the court for 10 months to achieve this outcome. I hope I'm proven wrong. I hope the court maintains Roe as the justices promised in their nomination hearings. But the record of activism from this court, from these Republican-appointed judges, gives me little hope. As Justice Stevens said in his famous dissent in Bush versus Gore, quote, "It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law," close quote. That confidence has been shaken this week. I hope it can be restored. With that, I turn to Ranking Member Grassley.
Well, first of all, this draft was February the 10th, and if that was the final draft, I think that decision would have been issued. So it's just a draft. We don't know what the final draft is, and yet we're getting the cart ahead of the horse. Another thing, I've heard people say that that these candidates lied to us. I don't know what you do when you question Supreme Court justices, but I'm looking at Are they for the original intent of the Constitution? Are they going to interpret laws the way Congress passed them, or if there's some sort of vacuum in the law, are they going to fill that in? Or are they going to let Congress do its work to change the law? And then another thing about holding a vacancy on the Supreme Court open for a presidential election, we've debated that many times, and I'm not going to repeat that argument. But if you think that on February the 10th of 2016, we knew that Trump was going to be president of the United States, that's a ridiculous sort of assumption. At 10 o'clock election night, 2016. I couldn't believe that Trump was going to be elected president, but he was elected president. So think that there's a scheme here that was thought out on February the 10th, 2016, that we were going to know that we were going to be able to put 3 justices on the Supreme Court is a ridiculous argument. Then also, getting back to what I said about the way I see in questioning judges and whether somebody lied or not, I could say to Gorsuch on the McGurk case, that's a ridiculous, nobody got that opinion in interviewing you here, that you go that far to say that half of Oklahoma, that the state couldn't prosecute Native Americans. I disagree with him on that opinion. Kavanaugh made some decision here within the last 2 or 3 years that I disagree with, but what's that got to do with what they told us here at this hearing? Or if you're talking about precedent can't ever be changed, it's ridiculous to think that we would say today that separate but equal is a legitimate way to treat people in public schools. No, Brown overruled that, and everybody's thankful that Brown overruled it. So we don't even know what this decision is. Now, those are some of the off-the-cuff remarks I want to make, but I want to also follow up on the same subject. On Monday evening, we saw a shocking leak from the Supreme Court. That was a monumental, historic breach of trust. A number of Democrats and their allies in the media have tried to focus on the substance of this leaked 3-month-old draft. Before everyone sets their hair on fire, there are a few reasons that make little sense. First, it is a draft, not a final decision. There will be time to discuss the actual decision in the case when that case is issued, or that decision is issued. We shouldn't reward this leak by speculating about it. Second, the person who violated the court's tradition of confidentiality chose to leak the draft. The draft is nearly 3 months old. We don't know what changes might have been made. But we have 3 Republican senators that have been clerks in courts, and they very carefully told us how many times these things change from day to day or week to week in this whole process of writing a final determination. Third, what we do know right now is that this leak happened. I don't know why some on the left want to lionize the leaker. This was a very dishonorable act. We should all be willing to say that it was a dishonorable act. It risks hurting important values and credibility at the court. The justices must be able to discuss cases without worrying that a member of the court family would run to the press seemingly in an attempt to influence an outcome. The Chief Justice has announced that the marshal of the court will investigate the leak. We all ought to look forward to learning the results of that investigation. Sadly, we're already seeing the predictable result of this disgraceful leak. We've seen the far-left dark money groups calling for court packing, and we've seen the public pressure campaign to influence the court. A liberal activist group even went so far as to organize a walk-by of a justice's home. Disgraceful. This seems to be nothing more than an appalling attempt to intimidate the justices. Appropriately, the Chief Justice announced, these are his words, that the work of the court will not be affected in any way. We should also remember the numerous dedicated employees who work at the court. All of the justices respect and cherish the court as an institution and its place in our government. We should recognize and honor those employees and the justices who have respected the confidentiality of the judicial process. Now to today's agenda. You may not believe this, Senator Durbin, but I want to thank you for enlisting the No Oil Producing and Exporting Cartel Acts, NOPEC. I also want to thank Senators Lee, Klobuchar, and Leahy for their co-sponsorship of the bill. NOPEC has been marked by this committee before and has always enjoyed bipartisan support. And by the way, we're dealing with a cartel, and every day, at least these on this side of the aisle, are always condemning cartels for bringing people illegally into this country. Cartels are wrong, whether it's at the southern border or it's a bunch of countries that are collusion to drive up the price of oil in this country. The Organization of Petroleum Exporting Countries, or OPEC, is a collection of countries that operate a cartel controlling the price and production of oil worldwide. It's not only the negative impact in America, it's the negative impact on the price everywhere. And while we in the United States of America are thinking about how our style of life has improved in the last 150 years because of fossil fuels, what that's done for us, we got to remember that 3.5 million people around this world are in poverty. They want the same life that we have, and they're not going to get it with windmills and solar energy just around the corner, like it might be in the United States. We got to be thinking about the helping the people that want to live like America lives. With its partner countries, Russia, OPEC controls 70% of all petroleum traded internationally and 80% of all oil reserves. The anti-competitive conduct of OPEC and its partners to manipulate oil prices directly harms American consumers. NOPEC would allow the Department of Justice to hold OPEC and its partners accountable for their anti-competitive activity. Importantly, the legislation only allows the Department of Justice to bring suit against OPEC and its members. It gives the Attorney General another tool in the toolbox to go after antitrust violators while still allowing the administration to weigh foreign policy implications. Americans are feeling the pain at the pump with record high gas prices, while Russia, Venezuela, Iran, and other hostile countries are benefiting. NOPEC is a bill that will help our government enforce the antitrust laws against these countries. Let me remind my colleagues that President Trump supported NOPEC, as did President Biden when he was in the Senate. So I urge my colleagues to join me in that. I also want to thank the chairman for listing the Justice and Mental Health Collaboration Reauthorization Act, which I co-sponsored, encouraging treatment and supporting those in mental health challenges in criminal justice system is critical to improving the outcomes and protecting public safety. This bill updates successful initiatives to do just that. I'm proud to help move this bill. Thank you.
Thank you, Senator Grassley. So several members have sought recognition, and what I'm hoping is, I don't know, probably to address the initial comments by Senator Grassley and myself about the events of this week, I want to move, if I can, to the nomination and then to the bill. So
I was just going to address the bill for 1 minute, but that's okay.
we're going to get to that. I promise you, Senator Klobuchar, and I'm going to recognize you for that purpose. So if members want to comment on the preliminary remarks,
I'll be brief.
I think Senator Cornyn does, then let me recognize you for that purpose. Go ahead.
Thank you, Mr. Chairman. I'll be brief. The actions of a person who had access to a draft opinion of the Supreme Court releasing it was an attack against the independence of our federal judiciary. This is really our crown jewels. As Justice Scalia once noted, many countries, authoritarian countries, have very fine-sounding constitutions and Bill of Rights on paper, but they don't respect the rights of individuals because they don't have an independent judiciary. That's the reason why we go through this laborious process of advice and consent for federal judges who serve for life, to protect their independence. And it's not just an attack against the independence of the judiciary. This risks violence against members of the Supreme Court and their families. That's why last night, Senator Coons and I introduced a piece of legislation to enhance the authorities of the Supreme Court law enforcement agencies to provide protective details for the judges and their families who've already been threatened with violence. I would point out that on March the 5th, 2020, Senator Schumer, the majority leader of the United States Senate, when the case was argued, appeared in front of the Supreme Court and he said this. He said, from Louisiana to Missouri to Texas, Republican legislatures are waging war on women, all women, and they're taking away fundamental rights. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions. That's outrageous. For a member of the United States Senate, supposedly responsible adults, people who understand the separation of powers and the importance of judicial independence better than perhaps most, because we deal in these matters on a daily basis, to make that kind of threat to the Supreme Court is an attempt to intimidate the justices and a threat to judicial independence. Now, I'd like to just point out quickly, by my count, the Supreme Court has overruled a prior decision of the Supreme Court, a precedent, 233 times. So assuming, as Senator Grassley said, this were a final opinion, and it's not, and we don't know how it's going to come out, but even if it was, 233 times the Supreme Court has overruled a prior precedent, and thank goodness they've reconsidered such decisions as Plessy versus Ferguson, the separate but equal case, the Dred Scott case. Now, some of our colleagues have pointed to discussions about precedent, but I think we, members of this committee, know, who are largely lawyers and who've had extensive legal practice, and some have even worn the black robes and sat on the bench and decided cases. We understand precedent to being something maybe a little different than what a layman or non-lawyer or non-judge would understand it to be. Not only has the court revisited and overruled prior cases, we know that as an empirical fact, But we've heard time and time again how the doctrine of stare decisis sets out a set of rules by which judges consider overruling a prior decision of the court. And what those considerations are. And though that is the approach that responsible judges take in considering whether to overrule a prior precedent. So some have, I think, understood the word differently than others, but there is no such thing as a permanent, inviolable decision of the United States Supreme Court, and thank goodness for that. Again, because when egregious mistakes like the separate but equal doctrine are handed down by the Supreme Court, we want a Supreme Court to go back and revisit it, and according to the analysis that is standard in that sort of situation, we want them to correct wrong decisions, to right wrongs. So, unfortunately, our colleagues have found this to be politically opportune. They'd like to distract the American people from their concerns about their shrinking paychecks and inflation, crime, the open border policy of the Biden administration. They'd like to distract them from our responsibilities around the world to protect democracies like Ukraine, to help them defend themselves, by focusing on this admittedly emotional issue. But somebody's got to be the responsible actor around here. We can't stoop to the level of the mob. We have to stand up and say what we believe and understand to be right, and about how wrong it is to attack the independence of the court by prematurely leaking a draft document, and then doing as the Senate Majority Leader did and telling justices, you will pay the price. You won't know what hit you. How wrong is that? How irresponsible is that? How dangerous is that?
Senator Leahy.
You know, I'm struck. Well, first off, I'd say as far as the leak is concerned, I have total confidence in Chief Justice Roberts and his team investigating that appropriately. We can talk about it all we want here, but the Senate has no jurisdiction over that. And I can't help but think that some who keep talking about the leak, make me think of the distraction in the movie Casablanca. I'm shocked that gambling's going on here. The fact of the matter is, if they talk about the leak, they don't have to talk about what the facts are. The facts are very simple. The Republican leadership broke all precedent and blocked for a year the nomination and hearing and a vote on a very well-qualified judicial nominee, Merrick Garland. They did that and made it very clear they were doing it because they wanted people that were handpicked by groups like the some of the groups that wanted to have particular justices on the Supreme Court. They did that. They even, at the end of Donald Trump's term, broke precedent and even Senate rules to ram through justices that had been handpicked to vote the way they would. And so to say shocked to see them vote this way, it was very clear that's what they were picked for, that's what they were confirmed for, and that's what they were intended to, that's the way they were intended to vote. My concern is that the Supreme Court is becoming more and more politicized. I voted for more Republican nominees to the U.S. Supreme Court than virtually any Republican on this committee. And beginning with John Paul Stevens and including Chief Justice Roberts. But what I worry about is when you have groups that tell a president who he must appoint because they are convinced that they will vote a certain way, that undermines the integrity of the Supreme Court. We can just try to distract people by saying, oh, the Senate's shocked by the leak. Of course there shouldn't be leaks, but that's something the Supreme Court has jurisdiction over, not us.
So Senator Lee and Senator Padilla have sought recognition. Senator Lee.
Thank you, Mr. Chairman. I was stunned a moment ago, Mr. Chairman, when perhaps I misunderstood you. I hope I did. I thought I heard you suggesting that Justice Alito had somehow been deceptive or dishonest in his testimony before the committee. I remember when he gave that testimony, and as you recited it now, he was correctly characterizing the standard under stare decisis. Stare decisis, of course, we have to remember, is not an inexorable command. Far from it. First, dealing with diminished standards of deference to stare decisis, to precedent, when we're dealing with the provision of the Constitution. Stare decisis takes generally the approach that it's better to have things settled than settled right. Now, that's the general principle. But it has limits. One of those limits is that, it's one thing to follow precedent when you're interpreting a statute. A statute can be changed. The Constitution can't be changed except under the very rigorous standards outlined by the Constitution, and that's why it's difficult. It's intentionally difficult. That's also why we give diminished deference to precedent under the doctrine of stare decisis when it comes to a provision of the Constitution. That's just the beginning of the analysis. The rest of it looks at a number of factors, including the nature of the error, the quality of the reasoning that went into it, looking at the workability of the rules, the extent to which the doctrine at issue is proven workable and judicially manageable as a standard, and the extent to which the standard at issue has brought about disruption in various aspects of our legal system, and of course the nature and extent of the reliance and what would happen in its absence. When you look at each of those standards here, it's not at all, it's actually quite difficult to defend Roe. And the fact that you're having to rely on stare decisis to begin with says something about the fact that it's hard to defend Roe as an original matter, hard to defend Roe, it's impossible to defend Roe as a textual matter. There's nothing deceptive about saying that Roe, being precedent, is entitled to respect. That's the whole point of the doctrine of stare decisis. The fact that the doctrine dictates that precedent be given due respect is not the end of the analysis. It states the reason for the analysis. I think it's unfortunate to denigrate the character and truthfulness of one of the most honest, decent human beings ever to serve in the federal judiciary and on the Supreme Court of the United States. I think before we denigrate them, we need to stop and consider what effect that might have on others. But more to the point here, I'd hope you'd stop and consider the fact that nothing in his answers that proved untruthful. Look, Roe versus Wade has been around for 48 years, nearly my entire life. I don't like it. I don't like it as a matter of policy, but more importantly, I find it repugnant as a matter of constitutional interpretation. It is wrong. And the opinion that's been leaked of Justice Alito is correct. I challenge anyone in this room to refute its accuracy on stare decisis and on the merits themselves. It's absolutely correct. And Roe versus Wade was wrong. It flies in the face not only of the text of the Constitution, but also the structure of the Constitution, hundreds of years of American and English legal precedent. It's wrong. Notwithstanding it being wrong, it's been in place for nearly my entire life. And at no point have I ever denigrated the Supreme Court of the United States or publicly attacked its credibility for the simple reason that as a lawyer and officer of the court, as a member of the bar, it's my duty to not do that. As one who has sworn an oath to uphold, protect, and defend the Constitution of the United States, it's my duty to not do that. Moreover, our federal judicial system, warts and all, mistakes and all, is the envy of the world. There is no judicial system like unto it anywhere in the world. It's been a key source of our strength as a country. This is a place where the rule of law prevails. So, notwithstanding the fact that I strongly have disagreed with Roe versus Wade, with a number of other decisions the Supreme Court has rendered, I do regard this as it's not a bad court that sometimes makes good decisions. It's an amazing court that sometimes gets it wrong. To suggest, moreover, as you have today, and as many of our Democratic colleagues have in recent days, to suggest somehow that the Supreme Court, once it renders a decision, is forever barred from reconsidering that decision is wrong. We've already heard mentioned today the fact that we're all fortunate that the Supreme Court was willing to recognize it had gotten things wrong in Plessy versus Ferguson, when it revisited the issue and corrected the error in Brown versus Board of Education. But there are countless other circumstances where that's happened, where that's been necessary, and the Republic has moved on. 32 years elapsed between the moment the Supreme Court of the United States stepped over its bounds and improperly invalidated a state law, a New York state law protecting bakery employees in Lochner versus New York. 32 years later, took 32 years during which there were lots of other bad decisions, inconsistent decisions, decisions not rooted in the Constitution itself and contrary to the structure and history of the Constitution, but rooted instead in judicial political activism, this time conservative judicial political activism. Thank heaven above that in 1937, 32 years after the original error in Lochner versus New York, the Supreme Court corrected that error in West Coast Hotel versus Parrish. Surely, Mr. Chairman, you would not be suggesting that it would be wrong for the Supreme Court of the United States to reverse itself if it had the unfortunate occasion to have to address something as horrific as the arguments that the Supreme Court embraced in Korematsu. Look, we've got to tread very carefully. We could lose what we have built up. A lot of us have put up for a very long time with decision-making that was wrong. Not just, and I'm not speaking morally here, although it is also that. Wrong legally, wrong constitutionally, wrong as a matter of policy and as a matter of constitutional structure. We have put up with that and still acknowledge the legitimacy of the court. We're treading into dangerous territory. Don't do that. Don't threaten and intimidate the Supreme Court of the United States. And make no mistake, that was the point of this leak. I don't know who did it for sure, but I'd bet money, and I'm not even a betting man, I'd bet money that this was done for the purpose of denigrating and delegitimizing and embarrassing and isolating those members of the Supreme Court of the United States planning on joining Justice Alito's opinion.
Senator, could you wrap up your remarks? We have a couple others who are seeking recognition. And
Yeah, look, I'd be happy to. I didn't come this morning planning on addressing this. I walked in and I heard you denigrating Justice Alito and Justice Thomas and Justice Kavanaugh, Justice Barrett, and Justice Gorsuch. This is not something I can just ignore. So I appreciate your desire to stick to the program. I would love to have stuck to the program today. The Supreme Court would have loved to have stuck to the program. The justices on the Supreme Court, who happen to have been appointed by Republicans, would love to have stuck to the program and not had their addresses publicly disclosed, with individuals being encouraged to go to their house and protest, something that has no place in our republic. You go to the home of a public official to protest, that is an implicit threat. You show up where someone sleeps and raises children. That's an implicit threat of physical violence. We deserve better than this. And I hope that each of my colleagues on this committee, regardless of their party affiliation or their position on Roe versus Wade, will condemn these actions and will condemn and distance themselves from any and all actions to threaten, intimidate, harass, or delegitimize the court itself or those justices thought to be joining this opinion. Thank you.
let me say at the outset that what you heard me say this morning were quotes, direct quotes from the individuals you've mentioned, and you can draw your own conclusions. I drew mine from what they said under oath before this committee. Secondly, I will once again state what I stated earlier, and Senator Grassley raised it in relation to another matter. There is no room for mob action, intimidation, or any personal threats against a public official, period. Whether it involves our home or otherwise, it is out of line.
Is it appropriate to show up at their home?
No. I don't care for people who do it to my home, and they have. I'm sure you don't either. There's no place in that, as far as I'm concerned, and I think it is demeaning and adolescent and not convincing at all when you're trying to plead your case by doing something that outrageous. We have Senator Padilla and Senator Cruz who've sought recognition, and then we'd like to go to the agenda of the meeting. Go ahead, Senator Padilla.
Thank you, Mr. Chair. I will have 3 points I want to make, and I will try to be brief. I know we have business on today's agenda to get to. And like Senator Lee, I didn't come in expecting or prepared to talk about what we're talking about, but I also can't sit silent as I observe a couple of things. Yes, we should be alarmed, not just at the leak, but at the substance of the draft opinion. Don't let concerns about a leak from the Supreme Court distract from the threat that the draft opinion that is now public represents. Roe v. Wade has been considered a matter of settled law for nearly 50 years. The vast majority of Americans agree with Roe v. Wade. And so the draft opinion that was unveiled, that it turns the potential removal of those protections from a potential to an imminent here. And regardless of what your thoughts are on a woman's right to choose, and I support a woman's right to choose, I will fight to protect a woman's right to choose what happens to her own body. Regardless of your thoughts on that matter, the rationale used in this draft opinion to take back the protections afforded by Roe v. Wade call into question so many other rights and so many other areas of what has been considered settled law, whether it's interracial marriage, access to contraception, or so many other fundamental rights. So it is alarming, colleagues. It is alarming. Don't be distracted on the dynamics of the leak. Don't ignore the significance of the substance of the draft opinion. It's that passion that you see playing out on the steps of the Supreme Court and in cities across the country. That's number one. Number two, Senator Alito spoke pretty passionately and eloquently. Senator Cornyn spoke earlier about the need to denounce threatening language that is out there now, publicly, through the press, online, targeting Supreme Court justices and their families. I agree. But to what Senator Durbin said a minute ago, threatening language, showing up in people's homes, the implicit threat of violence has to be denounced in all its forms. There's members of Congress that have been subjected to that, members of the Senate that have been subjected to that, secretaries of state in recent years, state and local elections officials that have been subjected to that. If it's wrong when it's targeting Supreme Court justice, it's wrong when it's targeting elections officials and so many other public servants across the land. And if you're going to denounce it consistently. And lastly, if we're going there, and clearly we are this morning, we also have to denounce things like conspiracy theories that Democrats are on the verge of expanding the Supreme Court to rush and seat recently confirmed Judge Ketanji Brown Jackson, soon to be Justice Ketanji Brown Jackson, so that we can protect Roe v. Wade. Stop with the conspiracy theories, please. Thank you, Mr. Chair.
So I've received a note from several members of the committee that they have to leave in just a few minutes. So I'm going to recognize Senator Cruz after I take this. I think it's going to be a voice vote on the U.S. Attorney for Alaska. The U.S. Attorney nominee considered is S. Lane Tucker for the District of Alaska. I understand we can consider it by voice. Does anyone seek recognition on the nomination? If not, on favorably reporting the nominations of S. Lane Tucker to be U.S. Attorney, all those in favor say aye.
Aye.
Opposed, no. Majority of the members present having voted in the affirmative, the ayes have it. The nomination will be favorably reported to the floor. I'm going to recognize Senator Cruz, and then we're going.
Senator Hawley wants to be.
I'm sorry.
Senator
Please.
Hawley wants to be voted no.
Senator Hawley needs to be recorded as no. Senator Blackburn, the same. Any others? All right, the record will so reflect. Before we go to the NOPEC issue, which will be the next item of business, Senator Cruz has sought recognition. Senator Cruz.
Thank you, Mr. Chairman. The topics that this committee are discussing are of enormous importance. I want to speak briefly to the substance, and also I want to speak about this leak that occurred. On the substance, I don't know what the final opinion of the court will be. If the final opinion of the court is anything like the draft of Justice Alito's opinion that was leaked, in my judgment, that opinion is a masterful opinion. It is correct. Roe versus Wade was wrong the day it was decided, and it's been wrong every day since then. I find it interesting that Democrat senators on this committee are astonished that justices would vote to overturn Roe. They're not astonished that every Democrat-appointed justice votes to continue Roe. Nobody on this committee has a moment of doubt as to how Judge Ketanji Brown Jackson would vote were she voting on this case. And it is interesting that many Democrats have decried this decision as a, quote, assault on democracy, because this decision is, if this is the decision of the court, is precisely the opposite. It is a victory for democracy. Part of the reason Democrats get so upset about this in Washington is the view of elected Democrats in the United States Senate on abortion is wildly out of the mainstream. The view of elected Democrats in this body is they support unlimited abortion on demand up until the moment of birth, with taxpayer funding and without parental consent or notification. That is a radical and extreme position. When asked if they support abortion on demand up until the instant of birth, only 6% of Americans say they agree with that position, yet that is the position of elected Democrats in this body. And so, when the matter comes to a vote, the people vote differently than Democrats in this body want them to vote. If Roe versus Wade is in fact overturned, it will not mean that abortion is illegal across this country. It will mean that we will return to the way the Constitution operated for the first 185 years of our nation's history, which is that the state legislatures have the primary authority to decide what happens. That will mean bright blue states like California, like New York, at least in the short term, presumably will continue with unlimited abortions. But it will mean redder states like my home state of Texas will adopt meaningful restrictions, and those laws will reflect the values and mores of their citizens. We have 50 states with Americans with very different views on this topic, and every Democrat who expresses outrage at the substance is saying those pesky voters have no right to have laws that reflect their values. Instead, they should be governed by 9 lawyers, unelected, but wearing black robes. If this decision is what's reflected in that draft, it is an incredible vindication of democracy because it's saying we the people can decide matters of utmost importance. Now let me turn briefly to the leak. This leak is the most egregious violation of trust at the Supreme Court in the history of our nation. It has never happened, even once, that a draft opinion leaks from the court before it issues in over 200 years of our nation's history. It undermines the independence of the judiciary, it undermines the integrity of the court, and it undermines the rule of law. It is difficult to describe, particularly to those who have not worked at the court or practiced before the court, the level, the magnitude of breach of trust that this leak represents. I fear for the court's ability to continue to function as it was designed to function if justices cannot circulate opinions and have deliberation and have discussions. The way the Supreme Court works, an initial opinion circulates, but there are hundreds and sometimes thousands of changes as the justices negotiate back and forth, sometimes sentence by sentence, paragraph by paragraph, footnote by footnote, having discussions back and forth and reaching a final decision. If that process can be circumvented by one unethical criminal law clerk, and I think the odds are overwhelming this was a law clerk who handed this over to a reporter, it does possibly permanent damage to the Supreme Court. And that decision to leak this opinion and to try to put political pressure on the court is the predictable culmination of a multi-year effort by Senate Democrats to demonize and politicize the court. As Senator Cornyn observed, Chuck Schumer stood on the steps of the Supreme Court in a direct effort to try to intimidate the justices of the court. The words he said, quote, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions." A direct threat to individual justices, vote the way I want you to, or you won't know what hit you. By the way, that same effort of intimidation was also reflected in a brief filed by Senator Whitehouse and others that stated, quote, "Perhaps the court can heal itself before the public demands it be restructured in order to reduce the influence of politics." Those threats have manifested in multiple Senate Democrats threatening to pack the court to add 4 new left-wing justices and increase it from 9 justices to 13 justices. And that bullying campaign also was reflected in the Arabella Advisors, the left-wing dark money outfit created to fight judicial battles, who led a shameful bullying campaign against Justice Breyer, including hiring a mobile billboard truck to urge him to retire. And let me finally point out that this leak, which follows that tradition of it's all politics, the ends justify the means, and the obligation that a clerk owes to his or her justice doesn't matter, when this leak occurred, the same left-wing activists who are funded by left-wing billionaires who have been leading this fight, they praise the leak. Brian Fallon, who's the executive director of Demand Justice, this left-wing outfit that engages in this, and by the way, a former aide to Chuck Schumer, Brian Fallon tweeted the following, quote, "SCOTUS leaks are good. Elite lawyers on both the left and the right, treating the court as precious all these years, have just been giving the cover to an institution that is wholly unaccountable. Rip the veil off." That's what their activists are calling. Another individual named Ian Millhauser, I don't know, but he's another left-wing activist, tweeted the following, quote, "Seriously, shout out to whoever the hero was within the Supreme Court who said, F it." And by the way, he didn't abbreviate F. F it, let's burn this place down. That's what the radicals on the left are calling for. Burn this place down, the Supreme Court, destroying the institutions that protect our nation. This is a sad day, and it is the culmination of deliberate decisions by elected Democrats.
We have two senators who have sought recognition, and the chair is, after those two senators, going to consider the legislation pending by Senator Grassley and Senator Klobuchar. The two are Senator Hirono and Senator Whitehouse. Senator Hirono. Your microphone's not on, Senator.
Okay. It's on now. I am frankly shocked that the Republicans continue to be totally shocked by the leak rather than the fact that we have radical right-wing justices on our Supreme Court who are poised to take away a constitutional right, not just any right, but constitutional right that women in our country have relied on for almost 50 years. That, to me, is a shocking thing. And to listen to my colleagues going on about comments that are made by organizations and individuals, that is called free speech the last time I looked. And I know for a fact that the Republicans are constantly talking about free speech rights. In fact, even describing the January 6th riot as legitimate political discourse. Give me a break. We are losing sight of the fact that in some 25 states, and in 13 of them, the minute Roe is overturned, abortion will be illegal in our country. The women in our country no longer will be able to control their own bodies, depending right now on what state you live in. And really, as we're talking about, make no mistake, there will be an effort, if Republicans take control of the House and Senate, to pass national legislation that will prevent abortion. The radical thing is that the Supreme Court is poised to let the states outlaw all abortions. 13 of them are prepared to do that, apparently, regardless of the circumstances, regardless of whether it's a 12-year-old girl who gets pregnant as a result of rape, incest, regardless of danger to the life of the mother. That is the radical thing. To eliminate a constitutional protection that the radical right in our country have been wanting for decades. And believe me, they have been very successful in packing our courts with over 200 Trump judges with lifetime appointments, including 3 to the United States Supreme Court. And it is thanks to the presence of those 3 new justices that Justice Alito and Justice Thomas, but particularly Justice Alito, because he is a justice who lets it be known, where he wants to go. The next is going to be revisiting Obergefell, the marital equality decision. But this is something that Justice Alito has been wanting to do for decades. We all know that. And now, thanks to the 3 Trump justices, he's going to get his wish. And the women of this country are going to pay the price. Thank you.
Senator Whitehouse, and then we will move to the no-PEC legislation. Senator Whitehouse.
Thank you, Chairman.
Disgusting.
If Justice Alito's draft opinion becomes law, women across this country will have had a constitutional right that most have enjoyed their entire lives taken away from them. I can't think of any time in the history of this great republic where a constitutional right has been taken away. In this case, a constitutional right that will have been taken away by a partisan cohort of the court. So let's remember what's outrageous here. Are people disappointed? Are people stunned? Are people outraged by the content of Alito's opinion? Yes, and properly so. Because this is a first for the United States of America, with a partisan cohort of the court taking away a constitutional right. If this decision was so wrong, wrong from the day it was decided, egregiously wrong, why did none of these justices say so in their confirmation hearings? I submit it's because they were playing confirmation testimony hide the ball. So that's a secondary outrage of dishonorable conduct with this committee by pretending not to notice the supposedly egregious mistake of Roe versus Wade when they were specifically asked about it during the hearings. Now let's address just for a minute what actually undermines the independence and integrity of the court. It's not this leak. What undermines the independence and integrity of the court is that for the first time in American history, the selection of justices got handed off to a private organization that had no transparent process for picking the judges, and that took huge anonymous donations while it ran the turnstile to the court. That is unprecedented in American history, and frankly, if we sent a judicial group to another country that was running its judicial selection process by handing it off to a secretly funded private organization with no public process for how the selections were made, imagine the harumphing we'd hear about that terrible, corruptible selection process. That is how the last 3 justices were appointed. And if that's not enough, once they were selected by these dark money donors behind this turnstile, then campaigns were put up, TV ad campaigns. People wrote $15 million checks, $17 million checks. And we don't know who they are, and we don't know what business they had before the court. And we don't know whether they were the same ones who were funding the Federalist Society while it ran the turnstile, and then came in with the checks for the Judicial Crisis Network when they ran the ads. You want to talk about undermining the integrity and the independence of a court? Turn the selection and confirmation process over to big dark money special interests, and this is what you get. It's actually worse because this is a court that is now instructed by flotillas of dark money front groups as to how to rule, The court cossets those groups by not requiring them to disclose who's behind them when they turn up. So we find out through other memos that big right-wing groups are orchestrating their word, amicus front groups to come in. That's something the court could clean up tomorrow if it wanted to. And then finally, we have a statistically improbable win rate at the court, an otherwise inexplicable pattern of victory for the exact interests that paid to select the judges, that paid for the confirmation ad campaigns for the judges, that are behind the dark money front groups that argue before the judges. I wrote an article years ago that put the tally in those decisions at 80-0. 80-0. And as to the outrage about threatening the court, if you're going to be outraged at people who are saying unpleasant things about the court, as Senator Padilla said, have the decency to be consistent. I didn't hear a squeak from anyone when Laura Ingraham, who has a way bigger audience than my little amicus briefs, went up on the air to say, we have 6 Republican appointees on this court after all the money that has been raised. The Federalist Society, all these big fat cat dinners. I'm sorry, I'm pissed about this. Her words, sorry. If this court with 6 justices cannot do the right thing here, doing the right thing here being rendering a decision just like Justice Alito's opinion purports to provide, then I think it's time to do what Robert Bork said we should do, which is to circumscribe the jurisdiction of this court. And if they want to blow it up, then that's the way to change things finally. Where was the outrage when a major Fox News commentator was talking about blowing up the court and changing things finally? If we're going to be outraged, please don't be so selective. And as to my brief, the comment that has been described as a threat was actually a quote. If you're going to criticize my brief, read it. It was actually a quote from a poll that showed the American public is concerned enough to think that the court might need to be restructured. Thank you, Chairman.
So now we're going to the NOPEC legislation. Senator Grassley, you gave an opening statement. Senator, your co-sponsor of the measure, Senator Klobuchar, is recognized.
Thank you. I would like to very, very briefly get at what you've all been talking about this whole time. I got to say that when I heard all the outrage about the leak, I don't like leaks. I understand why they're trying to figure out who did the leak. I get all this. But in the end, no one's going to care about that when that opinion comes out if it's anything close to what we just read. It doesn't just, when they say it'll take us back to the 50s, it's not the 1950s, it's like the 1850s. In the first page of that opinion, Justice Alito, and we now know he wrote it, he led with the word abortion is not in the Constitution. Well, you know what else isn't in the Constitution? Birth control isn't in the Constitution. Contraceptives aren't in the Constitution. All these things, rights that have been established over time by thoughtful justices, including Republican-appointed justices like Justice Blackmun, who was a Republican-appointed justice from the state of Minnesota, who wrote the opinion in Roe v. Wade. All of that, supposedly now, is going to go out the window. So if you want to hear outrage, you can be all outraged and outraged, but you're going to hear outrage at the ballot box, because time after time, people who aren't even that involved in politics, women, I can tell you right now, they're going to vote. Because the numbers show it, the polls show it, 70 to 80%. We can fight about this all we want, but you're basically taking a right that they believe is theirs and taking it away from them. And it's going to matter. So at some point, all the outrage about who said what and who paid for what and who did what, And I agree with what my friend Sheldon said here, but it's all not going to matter because this is going to be a really big deal to people. So if I were you guys, instead of just focusing on an internal court problem right now, I'd be focusing on what your constituents are going to be thinking about this and how they're going to feel. And if you want them to get on buses and have to go across state lines, and if you want them to die from a back alley abortion, because that's what's going to start happening here. So I work with you guys on stuff all the time, but if you want to be outraged, you're going to hear about what outrage is, and you got to think about the implications of this as opposed to what's going on over in the court, because it appears to be coming our way. If what we're hearing is true, this isn't just a single opinion by one justice, 98 pages, which I would term as precedent only when I want it to be. That's what that was. So you can be mad about a leak, but people are going to be a lot madder at you guys if you let this happen. So I am happy to talk about this bill I have with Senator Grassley because it gets at something else that's pretty outrageous that's going on right now, which is energy costs. And he and I don't agree on everything here. I do think I wouldn't be going after solar and wind. I think our future is actually a lot of choice in energy, and it is clean energy, and it is bringing down greenhouse gases and climate change. And I think the way you do that, in part, is by making sure that we have other sources of energy besides what we're getting out of the Mideast. And that means bringing down costs. And we've got solar, we've got wind, we've got biofuels, something that he and I work on together all the time. And one of the things that's been going on is that we have these high prices influenced by cartels out of the Mideast. And I introduced this bill with Senator Grassley because I believe that free and competitive markets in oil and natural gas are better for consumers than markets controlled by a cartel of state-owned oil companies. Every day in markets across our economy, consumers rely on competitive markets to keep prices low and the quality of goods and services high. Competition is the very basis of our economic system, but the fact is that we don't have free competition in global oil markets, and that means a lot less efficient energy markets that are less stable and are more expensive for Americans. Part of the solution, as I just noted, is other forms of energy and electric cars and biofuels and the like, but part of the solution here is making sure that our energy prices aren't controlled by international cartels. Under current law, the Justice Department is powerless to stop OPEC and its members from coordinating oil production to manipulate prices and supply, which drive up costs for Americans. That's why Senator Grassley and I have long been working on the No Oil Producing and Exporting Cartels Act, also known as NOPEC. The bipartisan legislation would explicitly authorize the Justice Department to bring lawsuits against oil cartel members for antitrust violations, meaning we would enforce U.S. antitrust law against OPEC producers or, and this is important, Russian state-owned producers if they engage in anti-competitive cartel activity. It would establish that neither sovereign immunity nor the act of state doctrine prevents a court from ruling on antitrust charges brought against foreign governments for engaging in the illegal pricing, production, or distribution of petroleum products. The NOPEC Act will help make gas prices fair and affordable here at home by ensuring the market is protected by robust competition. I urge my colleagues to support the bill.
Mr. Chairman, may I ask the sponsors a question or two?
Let me just say, of course, this is the point, and I'm going to invite any senator who has an amendment or wants to make